Jamie, I have tried everything I can figure out what this video is doing. So I will
Okay.
announce myself before I do anything.
Okay, thanks, Rich. That works.
At least I don't have to get dressed today. Oh,
We
Hey,
all
Chris.
appreciate your discretion, Mr. Wyszynski.
well, I'm in Florida, you know. Although tomorrow I'll be in Ohio for the snow flurries. Thank you.
Oh, great.
Oh, yeah. Yeah.
It's your fault, Rich. Thank you.
It is not. It was coming before I got there.
Mr. Chairman, it appears we do have a quorum. Both the appellant and the city staff are present. If you'd like to go ahead and start the meeting, we can get going. We will hear the appeal first.
Okay, thank you. Not having a gavel, I am bringing the meeting to order. We were going to address the appeal first. The city personnel like to present their case first.
Yes, Mr. Chair. If you're calling for staff to begin, I'm Chris Prosuti, and I'll be happy to get started if you'd like.
Okay, may I swear you in?
Pardon me, sir?
May I swear you in? Swear to tell the whole
Yes,
truth and nothing
please.
but you self be God.
I do.
Thank you. I'm assuming, Tony, that you got the names, so he doesn't have to repeat it. That's okay. Ms. Prosuti, go ahead. I think Tony's muted.
Thank you very much. Again, my name is Chris Prosuti, and my title is Chief Zoning Official with the Department of Building and Zoning Services. I have a brief prepared statement to make before I turn it over to the City Attorney's Office. This appeal before you today concerns the denial of zoning clearance for an application to replace a billboard that is on the roof of a commercial building at 4 East 13th Avenue, which lies at the northeast corner of North High Street and East 13th Avenue. The application proposes to replace that tri-sided automatic changeable copy billboard with a new LED automatic changeable copy billboard. But first, I have some housekeeping to do. The application was submitted on January 27th, 2020. The denial of zoning clearance was provided on February 20th, and the appeal was submitted 25 days later on March 16th. Therefore, this appeal was submitted within the 30-day window after the determination was rendered pursuant Code Section 3382.04. The Graphics Commission members were provided with a scanned copy of the billboard application, the written denial of zoning clearance, the appeal form, photos of the existing rooftop billboards, and the city attorney's response to the appeal. The same documents are available to put on the screen as needed, as well as additional photos that are referenced in the city attorney's response. So please let us know if you'd like to see anything in particular on the screen during this deliberation. The subject property is zoned in the C4 commercial district and also lies within the regional commercial sub-area of the University Impact District, which prohibits billboards as well as any automatic changeable copy signs in general. The University Impact District was established in 2017. Prior to that, the site was subject to the North High Street Urban Commercial Overlay since about 2001, which also prohibits billboards and automatic changeable copy signs. All right. As you can see in the photograph, there are actually two rooftop billboards on this building. A tri-sided automatic changeable copy billboard was somehow clatted onto the older static billboard. The city has no record of a permit or zoning clearance issued for either billboard. Absent any record that legitimizes the billboard, it cannot be considered non-conforming and therefore cannot be replaced without a variance. An unauthorized use does not ripen to a non-conforming use over time. And contrary to the appellant's assertions, the city not taking code enforcement action on this property because it was not aware of the billboard status does not make the sign any less illegitimate. The appellant also argues that the billboard should be considered non-conforming because it was allegedly installed at a time when billboards were not prohibited. But that is also an argument of logical fallacy because pursuant to City Code Section 330501, Even permitted uses are required to obtain zoning clearance prior to being commenced. Even prior to the enactment of Code Section 330501 and the requirement for obtaining zoning clearance, a building permit would have been required anyway. Yet there is no record of zoning clearance or a building permit having ever been issued for either billboard. The appellant, Mr. Hodge, communicated with the zoning office about this proposal prior to submitting the permit application to replace the billboard. Mr. Hodge was advised throughout those discussions that zoning clearance would be denied if an application is submitted because the billboard is not non-conforming. Mr. Hodge also communicated directly with the city attorney's office on this matter, and they concur with the position of the zoning office. Mr. Hodge informed us of his intent to submit the application, knowing that zoning clearance would be denied, and he indicated his intent to then file this appeal, and here we are. I now yield the rest of the city's time to Lara Baker-Morish, Chief Counsel of the City Attorney's Civil Division, who will provide the city's response to the appeal from a legal standpoint. I will remain available for any questions as well. Thank you very much.
Thank you, Mr. Persidi. Ms. Morish?
Yes, Chair Thompson, thank you for giving me the
Swear you in.
opportunity.
Excuse me,
Sure.
go ahead.
I swear to
Swear
tell
to
the
the
truth.
truth and nothing but the truth, so help you God.
I do.
Thank you. Go ahead.
Thank you. Thank you for the opportunity to present on behalf of the city and the department in this particular matter. I have provided a legal brief, but I wanted to speak more globally about what is and is not before the commission this evening. The question here on appeal is whether or not it was error for the department to have not considered this particular billboard to be a non-conforming use. That's the question. Was that error? Was it error at the time when Walter Green issued the opinion? Was it error now on appeal? It's the city's position that that was not an error. And crucial to that particular opinion and to that particular position is the fact that it is upon the applicant to demonstrate the non-conforming use. The case law is clear here. In order to demonstrate that a sign should be considered to be a sign that is a non-conforming yet legal permissible use, the burden of production and proof is upon the applicant to demonstrate that non-conformity and to demonstrate it was lawful at the time that it was erected. That has not happened here. What you see in front of you are two distinct billboards that have been joined on the structure that holds them, but that are in fact have two different histories. First, we have the billboard that is directly behind the trifold. You can see it peeking out there in this photograph. And there is photographic evidence to suggest that this billboard has existed since at least 1971. We know that prior to 1964, I believe it was, that the billboard was not there, but that as of 1971, photographs taken by ODOT demonstrate that that billboard in its static form did exist at that point in time. I also can say that, you know, there's a documentary about the University District that showed that billboard prominently during the OSU riots in 1970. That billboard has been around for a long time, and the department doesn't dispute that fact. However, what's being asked for here by applicants is not for this particular billboard to be changed into an LED. They're asking instead that the trifold that is directly in front of it be replaced with an LED. So the question is whether or not that billboard, the trifold billboard, can support that particular request. And that can only happen in one of two ways. Either the trifold itself, standing alone without the static billboard, can support being determined to be a non-conforming billboard, or this trifold is considered under the code to be a replacement billboard for the existing static billboard. It's only one of the two. Either way, the applicant has the duty to prove that it fits into one of those two buckets. Because if they don't, then they have to go to council and seek a variance, because currently, it's undisputed, currently the LED that's being requested would not be permissible in this district. So let's go and take a look at the two ways they can do that. Either they can demonstrate a sign that the trifold was erected, it in of itself, even if the static one wasn't there, would have been lawful. In order to do that, they're going to have to demonstrate when that thing went up. And why do they need to show that? Because there was a lot of changes, as Chris Prizzuti just laid out, to this particular zoning area and to the graphic code during the relevant period of time. It matters when this was erected. It absolutely matters whether or not it was lawful at the time. Second thing they can argue is, well, we know that the static billboard has been around for a really long period of time. Perhaps this is just a replacement for that static billboard. Okay, great. You still have to demonstrate that the replacement itself did not increase the nonconformity. And in order to do that, you have to know at what point in time it was replaced. Either way, we get back to the same question. When did this go up? What was the relevant law? And has the applicant proven either? The answer to all of those is, I don't know, and no. And as a result, this particular appeal must be denied. Thank you.
Thank you, ma'am. Is there anyone else from the city that needs to speak to this appeal? Not hearing anyone coming forward, we would turn to the appellant.
And quickly, Mr. Chairman, David,
Yes, sir.
David Hodge, if you have anything you want me to display on the screen from your appeal, just let me know and I can bring it up. We've got it stored in our folder here. So just tell me if you need me to display anything.
Sure, Jamie, and everybody, David Hodge here, attorney for the appellant. And I have a list of exhibits.
Mr. Hodge,
Yes,
before you
sir.
start, thank you. Swear to tell the whole truth and nothing but the truth, so help you God.
I do. I have a list of exhibits, Jamie. I don't know if I can be, share my screen with the commission.
You sure can, yeah. Go up to the top left, hit the share button, and then share content. It should be able to display whatever you want on your screen.
Okay, let me know if everybody can see what's up now.
We can see it.
Okay, very good. So again, David Hodge, attorney for the appellant. Great to see everybody. Wish it were in person. Seems that we're getting there, and I would ask for the commission's grace here, as it's a little difficult to conduct an appeal hearing with exhibits electronically. And I'd certainly ask for that same grace to be extended to the city folks as well as the city attorney's office. The first exhibit I have here marked on your screen as Exhibit A. If you look at the second paragraph there, it talks about the appeal needing to have been filed within 30 days. You heard from Mr. Prezzuti that it was in fact filed on approximately, I believe he said, the 25th day within that. I would ask the commission to consider what would have happened had I not filed this appeal within 30 days. And I think that the answer is that by operation of law, I would not have been able to bring the appeal forward. And so stuck with the city's decision, just by operation of law. I'd next like the commission to refer up to the first paragraph of this section, which says the Graphics Commission shall hear an appeal upon application and within 90 calendar days. I think today, if my math's right, and I'm terrible at math, is the 390th day before I'm before the commission. Now, it was filed on March 18th of 2020. We all can remember what was happening March 18th of 2020. And so 90 days came and went without any indication that this appeal would be scheduled. But I extended grace and said, you know, the Graphics Commission might not have even met for a month or two. So I waited to 120, I waited to 150, I waited to 180, and then I started asking questions about why this hadn't been scheduled. So I would ask the commission, as a procedural question, what happens if the appeal is not heard within 90 or COVID grace 120 or COVID grace 150? I believe that that my position is affirmed, just like my failure to file within 30 days by operation of law. Now, I'm going to flip down to Exhibit B, show the commission an email from Dave Rice, no longer with the city, that shows that the application was accepted on the 18th of March of 2020. Now, it's not me just making this up on the fly. There is some case law support for my proposition here. Bear with me and let me scroll down to it.
While you're looking for that, David, do you know when the commission, quote unquote, reopened?
Chair Thompson, I don't know with certainty. I don't know whether the commission didn't meet for 1 month or 2. And it's a fair question, but I believe that in any case, you were meeting well longer than 90 days before the appeal was even discussed with the city. And it was at my initiation, not the city's initiation. David, when do you want your appeal hearing? The exhibit on the screen now is Exhibit I. It's a case called English versus Roster. It's an Ohio Supreme Court decision from January of 1980. Flip down to some sites here in there that I've highlighted. You can see the first one here, and this case is about subdivision platting, but it is involving what is known as a default provision. It says here, citing to a Connecticut case, the court therein determined that the purpose of the statutory default provision was to ensure prompt and expeditious action on subdivision applications for the protection of the subdivider. And the court goes on, we too must conclude that the 30-day limitation in the statute is designed to ensure prompt action to protect the developer from bureaucratic obstructionism.
Is it possible that we could dispense with this point, Mr. Hodge, if we can figure out when the staff considers they reopened and when you actually made contact with them, and whether or not there was any specific reason for a delay past that time?
Sure. If we can do that on the fly, Chairman Thompson, I'm perfectly content with this being dispensed of on a procedural basis without going into the merits of the hearing.
Do we have an answer to those questions, Ms. Morris or Mr. Sudi?
If I chair, this is the first time Mr. Hodge is raising this particular argument. He hasn't provided with any of this case law, even though I provided him with my position yesterday when I filed it. He hasn't raised this in any email communications. He hasn't informed the city that he would be arguing this jurisdictional matter. If the commission wants to have this issue briefed, I'd be more than happy to do so. Obviously, I'm not prepared to do it on the fly. We had no idea this was.
Okay, then we're going to kind of put that point on hold.
Chairman Thompson, if I may likewise address the issue,
yes, sir.
The question that you just asked. I'm going to go back here to the citation in this case, which concludes having failed to comply with this mandatory step. The plats are approved by, that buzz phrase, operation of law. One of the documents distributed by the city staff and provided to the commission this evening are the rules of procedure for operation of graphics commission hearings. Jamie, I don't know if you have that on the ready, but we can certainly, if not, I can fumble around here and get it. If you scroll through those, it's clear that in an administrative quasi-judicial hearing such as the one we're in tonight, that the rules of evidence are significantly relaxed. I also would like to say that I did receive a written brief from the city attorney's office either yesterday or the day before, but it is ultimately a decision of the graphics commission, and it is not outside of the norm for these arguments to be raised and made here on the floor of this hearing at this time.
I do have the rules ready if anybody would like to view them.
Sure, Jamie. I'd like to view them just for the benefit of the commission.
I
So that
would,
we,
Jamie.
so that we can look and just prove or verify that the rules of evidence are relaxed in this type of hearing.
Chair Thompson, I'd be willing to stick evidence are relaxed.
I'm sorry, ma'am, I couldn't hear you.
I'm saying I'm willing to stipulate that the rules of evidence are relaxed in an administrative hearing, but that's not the issue of whether or not an issue has to be raised for the jurisdictional matter.
Okay. If they're willing to stipulate the rules are as you're proposing them, Mr. Hodge, are you willing to go past this section?
I am willing to go past this section, but I believe that this is a matter for the commission to decide here this afternoon, and would urge you to do so. So yes, let's leave the procedural issue for now and go on into the merits of the case. And certainly, I'm happy to answer any questions that anybody has. Let me go back and try to share my screen again. Okay, can everybody see this?
Yes, sir.
Okay, great, thank you. So a lot of this was already covered, but just to go back and discuss exactly what this is. Of course, it's a billboard that is on the roof of a building that has been there for 50 years total. That was converted to an automatic changeable copy sign approximately 25 years ago. So we're talking about something that's been there, for half a century, a very long time. The city has never issued any type of enforcement order or any other type of order whatsoever across that entire 50-year term. Not one single solitary, according to the city, notation throughout its entire records regarding the existence of this billboard. Exhibit C shows what it is. Some additional pictures similar to what you saw from the city, existing conditions of the billboard, aerial view of the billboard. Exhibit D, also an aerial view of the billboard on the roof from several different angles. There's a street view kind of around the perimeter of the billboard. The city's correct. It's been on there 50 years, as I said. We have both independently verified through the Ohio Department of Transportation aerial photography that it was there on or about 1971. That is on your screen here as Exhibit E. This is a certification page provided to me from the Ohio Department of Transportation. You can see here June 4th of 71 is about the time that the sign first appears on the building. You can see that here highlighted in yellow from ODOT. These are those aerial photographs. This is probably a little hard to see. I'm happy to blow that up, but the city has agreed that this is a fact, and so I don't know that I need to do so, but if anyone would like for me to zoom in on this image, I'm happy to do that. Same thing, that's July of 73 aerial. Flipping over now to zoning. So what you have on the screen now is Exhibit F, is the zoning map from the city effective in 1971. You see over here circled in green that the property is zoned in the C4 commercial classification. Flipping over here to the zoning code that was in effect at that time, down here, if you can see my cursor, is C4. Essentially what that says, similar to today's code within C4, all of the uses of C3, C2, and C1 are permitted. So you jump up here to C3, and it was shocking for me to realize when I read this that right here in section A, among the permitted use is a billboard and advertising sign, not in advance of any building line. So a billboard was just a permitted use at the time that this billboard was installed. Not that way today, but it was at the time that this billboard was installed. So flipping down here to Exhibit K, the city discussed the issue of the conversion of the sign from the static billboard to the trifold. And when did that happen? Well, according to my client, whose family's been in possession of the property for decades, it's been there approximately 25 years. I know that was a major issue that the city kind of raised in its brief, and maybe tonight in the presentation, or both or either, I'm not sure which. Had a conversation. If anybody would have asked me any time, I would have said, hey, I'll go get my client to sign an affidavit as to when that trifold was there. The same people have been in possession of the property for a very long time. So here you have a letter from Oxford Realty, the owner of the property. It's dated today. It is signed by Scott Solomon, a principal there. His signature's notarized. It's a sworn statement. He says he concludes here that the trifold's been on the roof for a considerable time, to the best of his recollection, for at least 25 years, possibly longer. So what does that mean? Well, if you go back to the case that the city cited in its brief, which is a case, I believe it's called Beerline versus Grandview. It's a recent case. Matt Beerline is a guy that many of you probably know at National Church Residences, and this is the case. The city cited this case for the proposition that it's our burden to demonstrate that the signage here is legal nonconforming. So let's talk about that issue here just a little bit, because it seems like that is the crux of what we're getting at. Burden of proof to establish a nonconforming use is on the landowner. Case goes on and it says that there are two prongs that we have to meet. To demonstrate a lawful nonconforming use, a landowner must establish the following two requirements. The first one is that the use, the billboard, was in existence prior to the enactment of the prohibitory land use regulation. I just now showed you some exhibits that shows definitively that the billboard was a use permitted by right under the law at the time of its installation. So we meet prong one. I just now showed you a letter from Scott Solomon, signed and notarized, a sworn, essentially affidavit statement that the conversion to trifold occurred back in '96 or so, before the prohibition of automatic changeable copy up High Street. So we meet prong one for both elements here. Prong two, that the land use in question was lawful at the time the use was established. So again, billboard was a permitted use 50 years ago and 25 years ago when it was converted to automatic changeable copy. The case goes on and says, stated another way, the use in question must have been in full conformance with all applicable land use regulations in effect when the activity was begun. The sign has been there for 50 years. The city has never done a single thing to enforce the existence of that sign. Now, they might say, and have said, well, you don't have a permit. And we've asked the city to review records for the permit. In conversations over the course of the last year plus that I've been working on this with various people, both former city employees and long-term practicing zoning attorneys in town, about what happened with city records. They've told me among the following things. David, when we went from Marconi to Fairwood, it was insane. Lots of things were tossed. Lots of things were ditched. Lots of records got lost. There was a time that the city kept handwritten records during this time frame. They then converted that into the first computer system called the Burroughs system. When they converted to the Burroughs system, they had in-house people do the conversion. They also hired temps to do the conversion. Not everything was entered. And the city, in my opinion, knows that not everything was entered. In fact, I was told that they went back, they would have a building, they knew the building was there, they would go back and recreate the record just so they would have some long-term documentation of what's there. And, you know, we can imagine that happened. I mean, certainly society has gotten to be more and more sophisticated over the last 50 years. And before that, you know, the 50 years before and the 50 years before. So I'm not faulting anybody. I'm just saying that records across the last 50 years in the city of Columbus have been lost. Same thing happened when they went from Marconi, you know, from Marconi to Fairwood, from Fairwood to Carolyn, and recently from Carolyn back down to North Front. Those are facts. One of the things that I'd also like to use this same beer line case for, and it's something that I love as a practicing zoning attorney, because it's powerful and it's, you know, in some ways American, and it talks about who we are and what zoning is. And that's what we do when we interpret, what our obligations are when we interpret zoning resolutions, which essentially are zoning codes, which is essentially what we're doing here tonight. These highlighted sections, I think, are great. And this is the case, again, cited by the city, a recent 10th District Court of Appeals decision, the beer line case. The court should give the words in a zoning regulation the meaning commonly attributed to them unless a contrary intention appears in the regulation. Now, I cite that for the proposition of 90 days. And what if I hadn't have made my 30-day appeal period? You know, I wouldn't have come in and said, dang, guys, give me, you know, I'm a day late. The city would have said, a day late and a dollar short, David. You ain't getting your hearing on your appeal. Indeed, the primary goal of statutory interpretation is to give effect to the intent of the enacting body. So that's the intent, that's the policy. The policy was cited back in that English case. It's so that there's not bureaucratic obstructionism, I think is the phrase used in that case. A zoning provision must not be viewed in isolation. Rather, its meaning should be derived from a reading of the provision taken in the context of the entire ordinance. Same time, when an ordinance is unambiguous and conveys a clear meaning, the court must only read and follow the words of the ordinance. A court must adhere to the plain language of the statute or ordinance unless an ambiguity exists. If an ambiguity exists, courts must strictly construe restrictions on the use of real property in favor of the property owner. In favor of the property owner. So I believe the case I've presented to the commission is crystal clear. I believe this is a legal non-conforming use from 50 years ago. I believe this is a legal non-conforming use from 25 years ago. I believe that the evidence that you have heard that I have presented shows that definitively. I believe that even if somebody here thinks it's vague and ambiguous, this beer line case in the Ohio Supreme Court has said over and over and over and over again that these types of things are in favor of the use of the real property proposed and not in favor of the regulation or the regulating agency.
Mr. Hodge,
I feel that I've
we
left
need to
some
wrap
stuff
this.
off.
We need to wrap this if you can.
Yes, sir. Yes, sir. I feel that I've left some things out, but I think I'll stop there. Really appreciate everybody's willingness to take these things into consideration. Certainly be here to answer any questions that anybody's got about the exhibits that I've shared or anything in the presentation. And thank you all very much.
Thank you. Let's see, Mr. Freeze or Mr. Pizzuti or Ms. Orish, can you answer the questions about whether or not it was actually needing to be permitted at the time it was installed?
Thank you, Chair Thompson. I'm sorry, the question was whether or not it had to be permitted at the time that it was installed? Is that the
Yes,
question?
ma'am. Yes, ma'am.
Thank you. I'm sorry to put it on me. And the answer to that question is likely yes. And I wish I knew definitively, because the problem here is that we still don't know when this trifold was installed. We have a letter that allegedly a sworn letter saying approximately 25 years ago. This same family has owned this building and owned this billboard since 1993. They've profited by putting up this additional billboard. It went from 1 static to 3. That means that they had increased in revenue, that they could easily go back to their financial records and tell us when that happened. They would have had to hire an erector in order to install that thing. I'm doubtful that they themselves put it up there. Somebody put it up there. They had a contract to do that. That could have been offered to the commission. They would have pulled a permit. And they're saying, well, the city might have lost it. There is not a single permit related to this billboard at that location, not just going back to 1971, but from 1996 going forward. There isn't one. It doesn't exist. They're also not on the registry. There's a billboard registry. The city required everyone who owned a billboard, whether it be conforming or non-conforming, it's simply an administrative registry. They didn't register their billboard. This entity, the ownership entity, has not changed. They know the answer. They haven't proven it. And as a result, I can't answer your question, Chair, because I don't know which zoning law was in effect when the trifold was installed.
If I may, Chairman.
Let me just a second. Let's assume that the records are not available for when it might have been installed 50 years ago for the static billboard. But Mr. Hodge, for the trifold billboard in 1996, are you telling me that there are no records of permit or application for it as well?
Yes, and I don't believe that one was necessary because there was no prohibition to automatic changeable copy at that time, Chairman Thompson. And, you know, in contravention to what council just said, the exhibit on your screen is a sworn statement from the ownership entity of this property that the trifold has been there for at least 25 years, which predates the automatic changeable copy prohibition. And you know, the way these billboard things work is it's not this family that you know advertises on this billboard. They own the real estate, and they've contracted over time with Clear Channel and Lamar and you know others that do this in our community, Orange Barrel Media and the folks that do that. They control the structure and the advertising and the whole caboodle. So this property owner, they have a lease, and it's a long-term lease, and that lease enables the Lamars and Clear Channels of the world to go out and do what they do, and that's exactly what's happened here.
So are you implying that one of the erectors in town put this trifold up without a permit and didn't register it?
No, sir. What I'm saying is that no permit was required. In
1996. Is that correct, Ms. Morris?
It was a replacement of an existing sign, and there was no of an existing billboard, and there was no prohibition to automatic changeable copy.
I'm not worried about the automatic changeable copy. I'm just worried about whether or not a billboard permit was properly applied for and permitted in 96 when the additional billboard went up. Whether or not it was changeable copy or not, it might have come before us or something, but I don't think you would have been able to put it up without some sort of permit.
Yes, that is correct, Chair Thompson, and I can defer to my staff who can probably give you the more specifics, but I believe there has been a requirement for a certificate of zoning approval since 1966, but I'll defer to Mr. Prizzuti if that's the correct date or not.
Thank you very much. That is correct. In 1996, and certainly for at least 20 years prior to that, a certificate of zoning clearance was required to replace a billboard or to install a billboard. And frankly, I would believe that we would have required the original static billboard to be removed in order for us to approve the tri-sided billboard. Just because a billboard was not prohibited just because a billboard was a permitted use of the C4 district in 1996 does not mean that it did not also have to get zoning clearance. It did not get zoning clearance. There is no record of zoning clearance. It also required a permit. There is no record of a permit for it either. So again, just because it was allowed does not mean that it is a non-conforming billboard because they did not get a permit for it.
Is there any chance that these records were lost, Mr. Prizzuti?
There was
1996.
There is always a chance of records being lost, but we have plenty of records for billboards before and after 1996.
Okay.
It is extremely unlikely. I have no reason to believe that that occurred. So I think that's a pretty weak argument to say that of the 44,000 permits that we issue every year generally, that maybe some records are not kept or may have been lost. No one would dispute that. But we're talking about this property, and not even the owner of the property could produce any record of a permit that was issued to allow them to install that sign.
So if I might just, and Chris, with all respect to you, and you do know that I have a tremendous amount of respect for you, the comment that you just made is it's a weak argument to say that a record may have been lost. You did acknowledge that records are or have been lost. You said that you have no reason to believe that happened here. I would just as a comeback on that say it's an equally weak argument to say that a billboard that's been on a building for 50 years is not lawful.
Why is that, Mr. Hodge?
Because it's been there for 50 years. It's been there for 50 years it's been there for 50 years as a billboard. It's been there for 25 years as an automatic changeable copy billboard. And on High Street up in the University District, nobody's come out not one time and cited them for code enforcement or anything else, Chairman Thompson. You would think that with a concerted effort to reduce the proliferation of signage, kind of one of the stated purposes of the Graphics Commission, that somebody on the Impact District Review Board, the Area Review Board, the University Area Commission, some neighborhood advocate would have come out and said, "What is that doing there?" And the city would have done something. Nothing has happened. So I think there's strength in that argument. Is there
any sort of thing that you can he could stand on that says that if we do not cite a non-conforming use or a billboard or a sign or something that has been in place for a certain number of years, that it then takes on a grandfather sort of condition of non-conforming use?
No, the case law is just the opposite. The mere fact that it hasn't been cited doesn't confer non-conforming status upon a billboard. I would also argue that over that same period of time that Mr. Hodge is incredulous the city hasn't cited the billboard, that billboard has also not been registered in the city billboard registry. That was the specific intent of the registration that was enacted with the graphics code, to make sure that the city was aware of where all of its billboards were located, because we were having concerns about billboards, and this billboard hasn't been registered since 1997.
In fairness, Ms. Baker-Morrish, I think your materials say that the billboard registry was adopted somewhere around 1997, if I'm not mistaken. This billboard's been there since at least 1971. Codes change all the time without property owners knowing. Nobody with this organization, to my knowledge, had any way of knowing that they had an obligation to register the billboard, and how would they?
Mr. Hodge, I believe you just stated that the owners of this particular billboard worked frequently with Lamar and Clear Channel, who have complete knowledge of the graphics code and the billboard's requirements. I would also go back and state, in terms of when this particular trifold was installed, to Mr. Hodge's point, he's correct. The owner is rarely the individual that's working with and installing the billboard. They have a contract, they have a lease. Also more potential evidence of when they would have had contracted with Lamar or Clear Channel to demonstrate when that trifold went up, and information, documentation that has not been provided to the commission.
Can you provide that sort of information, Mr. Hodge, of who they contracted with to put up the trifold and when it was installed?
I know that this, to my knowledge, Chairman Thompson, this lease has been between either Clear Channel or Lamar. I don't know who it was with 25 years ago. I've had my client review their records. So it's not information I can provide. But again, my argument is that 25 years ago, there was no prohibition to automatic changeable copy, and all they did was take a static and convert it, and they did so lawfully.
Okay, thank you, Mr.
Can I
Hodge.
ask a few questions here?
I was going to ask, do we have any questions from anyone?
Yes.
So,
Mr. Hoare?
Mr. Prizzuti, if
Oh, I'm sorry, Mr. Prizzuti.
I know this is Brian Cooperman speaking. I just had a couple
Oh,
questions
Brian,
for
sorry.
the city
I
staff.
can-
If there was definitive evidence that you saw that what Mr. Hodge is saying, and that there was the automatic changeable copy installed in '96 prior to the code change, then would you agree that his argument is valid and the appeal should be sustained? And it's simply you don't have the evidence? Is that the main issue here?
It depends. Then we go to the step 2, which is whether or not when it was installed lawfully with the replacement allowances under the city code. Did it increase or decrease the nonconformity? Did it increase or decrease the space between the billboard and the right-of-way? Those things would then need to be looked at next, but we can't even get to that point because he hasn't met his burden, is the city's position.
I thought that's what we're talking about today. I mean, really, the issue is whether or not it was changed prior to the '97 code change, correct?
And it's both. It's whether or not it was changed prior to the code change, and also whether or not when it was changed, it was done so in conformance with the requirements of the code, that it not increase the nonconformity. Mr. Hodge has not offered any evidence to demonstrate whether or not the trifold is either larger or smaller than the one prior to it, whether or not it increased or decreased the amount of distance between the billboard and the right-of-way, and whether or not it was properly and lawfully installed, which goes back to the question of whether or not it was properly erected, whether or not it was registered. All of those things are things that we get to once we determine when the incident occurred, when the event happened. Then we can look at the relevant statute, then we can assess the situation, but we don't have that information before us to make that call.
Right, and you also don't have records. You also can't definitively say the city kept proper records and could have lost the permit and you could have had it. I mean, that's kind of what I heard. I thought Chris say, unless I'm mistaken.
Well, just for clarification, I think that given the extraordinary amount of records that the city has, we went through a scanning process that took about 18 months prior to our moving downtown, and more than 8 million documents were scanned. So I don't think anybody with the city can claim that all of the records that have ever been issued are kept and are intact. That would be an absurdly bold statement to make. I don't think anybody can say that. Having said that, though, I think it is highly unlikely that we would have lost a record for this, because we do have records of other billboards. We have records of billboards around this time. And again, Mr. Hodge keeps insisting that it is very likely that this billboard was installed at a time when it was not prohibited by the zoning code. No one disagrees with that. What we're saying, though, is that when it was installed, it was required to get zoning clearance. We have no record that it got zoning clearance. So for anyone simply to say, well, the city probably lost their records, so we should be given a pass on that, then that's why we have the case law that Ms. Baker-Morish cited that says that the burden of proof is on the applicant.
Yeah,
what I'm trying to do here
myself is when the city's lost records that, you know, I've just been told the same thing, being an attorney and dealing with it before. So I understand it's a tough statement to make that we never lose records, and it's you maintain so many records. I've just dealt with that situation personally, so that's why I was asking the question.
It's also very convenient.
Sorry, may I be recognized on that question?
Yes, ma'am.
So I would also state that whether the city has or doesn't have a record presupposes that somebody has actually submitted a permit and pulled a permit. And once again, the family in this particular case who owns the property and would have hired the erector and would have paid for the billboard to be installed could offer testimony, could offer a statement and saying, yes, I hired so-and-so erector. maybe I don't remember the exact year, but I hired so-and-so erector, and we paid roughly X amount of dollars, and we asked and pulled a permit. We don't have that either.
The sign company does that, and it's 25 years ago, so that's not fair. At the same token as he's claiming the city should have the record. So I think it's a tough.
I'm saying I'm not saying a record data from 25 years ago. I'm saying we don't have even the owner saying I hired somebody to put up this sign, and we filed.
If there was never anything applied for, or Brian, how could the city have it?
Right.
Sure. But at the same time, I'm a very organized person. I keep tax returns and I keep records for 10 years. I don't keep them for 25 years.
Yeah.
And I'll say that, and I'll say this too. There was a suggestion that the family reach out to Lamar or Clear Channel and provide this information. Part of what's going on here is that they're working with a new company, and Lamar and Clear Channel don't want to lose this relationship.
Well, that's the decision of the applicant then. Ultimately, the burden is with them. They decide what evidence they choose to submit, and that evidence is not here.
And I believe that it is here.
Chair Thompson?
Yes, sir.
Prior to Mr. Hodge coming in to see us about this proposal, I met with the regional manager of Lamar Outdoor Advertising. This is shortly after they took over Clear Channel. The gentleman's name is Christopher Avendet, and he met with me very shortly, a short period of time prior to Mr. Hodge meeting with me, and he's brought this matter up to my attention. He asked about this billboard. That is when we looked into this and found no record of it. He indicated, I didn't think so because we don't have any record of it either. And I explained that if you do want to convert this to a automatic changeable copy LED sign, you're going to need a variance to do that. But keep in mind that this is within the impact district that does not allow billboards, that does not allow automatic changeable copy, and it is subject to the review board of the university district. So it is very unlikely that it would be supported. Mr. Avendet told me then that after consideration, he decided that it would not be worth pursuing any action to legitimize the existing sign or to get a variance to replace that sign. It was a short time after that that Mr. Hodge contacted us with the same proposal, and we went through the same process.
So let me just add a little bit of information there in fairness. I do remember, and I think it was probably you, Chris, that told me that Lamar came to see you. Lamar took over the Clear Channel portfolio. So Lamar hasn't had this long. It was Clear Channel that had it before that. Who had it before that 50 years ago, I can't say.
Okay. I think we need to come to some conclusion here.
I did have a question.
Okay. Mike.
At the beginning of this presentation, I know you mentioned billboard registry, but I thought I saw in the photograph there was the number. It was like a 6-digit number. So the billboard is registered. Is that correct? And if it's registered, who is it that keeps tabs on the registry numbers and all that? The opening picture showed that number. Is that the registry we're talking about?
Mr. Hoy, no, that is actually an inventory number that is controlled by the owner of the billboard. That is not relevant to any record the city has. That just indicates the number of the billboard owned by that company. It's not part of any city records.
Okay,
so
I see.
Isn't that traceable to some kind of record that the erector should have?
We don't know.
Mr. Hodge, wouldn't you think that if it has a specific number, somebody ought to have some record of it?
I can't answer the question. I would imagine that, I don't know the date that picture was taken. I can't speak to when Clear Channel or Lamar adopted that numbering inventory system. So
we don't know.
Can't answer the question. What I can say.
Who put up the trifold? We don't know who put up the trifold, right?
I think it must have been Clear Channel, Chairman Thompson, but I can't say that with certainty. Okay. What I can say with certainty is this has been a great discussion, and I think lots of powerful points have been made sort of on both sides of this ledger. Certainly. You guys may think I haven't made a single good point. I think I have, though. So what that leads me to believe that this area is gray. What our obligation is when you have a gray area is to decide against the regulation and in favor of the property owner. I think that's what the obligation is here, and I hope that that's what you do. And that's on the merits. That's not even to mention the procedural issue addressed at the beginning of the presentation.
So we kind of went past the procedural issue, but is there anyone else on the commission that has a question or a comment?
Does it make any sense to extend this for one more month, that maybe more evidence can be brought in? It seems like this date is the big factor. If it was 96, if the Tri-Vision was installed in 96 and did have a permit or had some obligation to it, and maybe, and I sort of understand, on outdoor advertising, the copy changes all the time and there's no permit to put up new copy. That's just part of the outdoor advertising. But to put up a device like the Tri-Vision, that is mechanical and all that. So I sort of see the permit issue for that, for sure. But the changing of the graphic or whatever, that could come or go. So there could be a misinterpretation of that. But
Right.
I don't know if one more month dragging this out. I know this has already been a long time, but I don't know.
We need to cut this off here too. But here, I'm a little leery of the fact that we're saying "quote unquote" 25 years ago, which puts it right on the line between 96, 97. Apparently, there's some changes in that period, and I'm to say it's been there 25 years ago, which might put it before some requirements, and say it was there 23 years ago and puts it into the requirements. I find that kind of ambiguous, and I'm not comfortable with that being a deciding factor. But at this particular point, my tendency is to say that if there were records from anyone, I'd feel more comfortable deciding on this. Does anyone want to take the time to try to find more records, or do you want to make a decision now?
I kind of want to, if Jamie would think it's okay, submit arguments on the jurisdictional issue that David brought up at the very beginning.
Okay.
I think it was proper for him to bring it up, but I also think the city needs an opportunity to respond if they weren't on notice of that argument previously.
Right. That was my point, Brian, that if they have never heard this before, we probably ought to have an opportunity for them to research it, respond to it, whatever they need to do. What do you think, Chris?
You're asking about the procedural matter?
I'm asking about whether you need, since Ms. Baker-Morris said you had not heard that argument prior to this, do you want to take another month to research an argument for that, or do you want us to decide upon it here?
If I may, I'd like to at least address this before any decisions are made.
All right.
When Mr. Hodge approached us with this billboard proposal, he had another billboard proposal elsewhere, actually in the downtown district. After he filed the appeal, he indicated to us that he wanted to pursue that other billboard issue because that was a priority over this one. Mr. Hodge is one of, if not the most prolific applicants we have for rezoning and variance applications. Not a week goes by where we're not in contact with Mr. Hodge or Mr. Hodge is in contact with us. If he wanted this application, this appeal to be scheduled for a Graphics Commission hearing, all he had to do was tell us. In fact, he did tell us at the end of 2020 that he wanted it on the agenda before asking us to table it. He asked us to put it back on the agenda in February, and then he asked us to take it off. And then he asked us to put it back on for this month. So we have not in any way been reluctant or resisted scheduling this case at any time. I think that he's just attacking the process because I think that the appeal lacks merit.
Very, very well said, Chris. I think the appeal does have merit. It was COVID, and I knew things were going on. I certainly don't remember saying that I wanted to work on the downtown Neal Avenue thing in advance of this one, and that being an issue with scheduling. The fact of the matter is, if I hadn't filed in 30 days, you guys would have said no way, no how. I think the same rule applies. If it's not heard in 90 or COVID grace 120 or 150, then it's no way, no how. It's just an equity issue, and it's fair is fair.
But you have to look at how many days we were off, Mr. Hodge, and then you have to, I wonder about if you ask them to put it on or take it off the table at any point.
Yeah, that was the request to schedule, and then the request to table was a scheduling conflict well beyond any 150, 180 days, Chairman Thompson, well beyond.
Chairman Thompson,
yes, ma'am.
Thank you. That's a COVID-related issue. If everybody recalls, there was a state of emergency that was declared by the governor in March of 2020. In addition to that, though, there was also a state of emergency declared by Mayor Ginther in 2020. There were specific provisions of both of those state of emergencies, both of which, by the way, are still in effect, that allowed for a variety of continuances to occur and for the change for both boards and commissions and for a relaxing of any of those particular provisions that could not be brought forth because we were unable to meet in person during that period of time. As everybody in this commission remembers, it took us a significant amount of time to get the technology necessary in order to comply with the provisions of Senate Bill 197 that allowed for open meetings to be conducted in a virtual forum. The city was in compliance with that. The mayor issued executive emergency orders related to social gathering. And while I don't have all of those specific dates and times in front of me because I was not put on notice of this particular issue, I would be happy to provide the commission with all of the existing emergency orders that were in place during this period of time that related to the commission's hearing of this particular appeal.
I have had, from what I'm remembering, Mr. Hodge, I don't think I'm in favor of allowing that particular point of view because of the fact we're probably still in a situation where we couldn't meet in person and lots of things have been continued. So I would allow the city to come up with whatever dates and or legal proceedings that went on to make this into even the permission to have virtual meetings. So the timing, I'm not sure I see where you've been actually hurt more than the norm for everyone else in the industry. I would tend to think we ought to, just for procedure's sake, be allowing the city to come up with those facts and figures so we could dismiss that particular point. But if you'd rather we not go another month,
I would propose that both sides have the opportunity to submit another written brief to the commission that we can review and at the next meeting can issue our decision. That would be my suggestion.
I'm in favor of that. Is there a motion for that?
I move a motion to allow one more month for gathering.
Do I have a second?
I'll do the second. Motion. Can I just say for the record, what I said was I hope to provide the city and the appellant to submit a written brief in response to this hearing related to the jurisdictional issue and give each side an opportunity to present their case with respect to that issue, and then any other additional evidence they can provide, I guess, related to the case and submit it to the commission, and we can decide at next month's meeting.
Did you get that, Tony?
Sorry, Tony, if I said that too fast.
I have a motion and a second for us to delay this meeting based on the statement that Mr. Koopman just made. Do I have? Can I do a voice vote on the motion, Mr. Freeze?
Yes.
Okay, all in favor of said motion to postpone this appeal until next month? Use a sign of aye.
Aye.
Aye. Opposed? I don't hear any. The ayes have it. We are tabling this appeal until next meeting. Thank you.
Chairman Thompson, if I might ask the commission if there's a date certain by which we need to have the briefs in for your review.
I would
Mr.
I
Freeze?
defer to Jamie. Yeah, defer to Jamie. He's the one that organizes everything. Whatever Jamie says, I'd be fine with.
And I would presume that Mr. Hodgson, his would be due first, and then we would have a response.
I disagree with that.
I would think you just both submit.
Your
Yeah.
motion, David.
I think they would just both submit, Jamie.
You want to get an unfair advantage on me, Laura?
You're good.
Oh, I know.
Jamie,
Yeah.
we're just going to let you take care of the administrative procedures to get that in from them.
I will handle it. I will discuss this internally, and we will have a date for you, David.
Okay.
Thank you all very much.
Let's
Thank
move
you.
on. We have any other business before we go to application 1? If
No,
not,
Chairman Thompson, we can
let's
proceed
have
with
the applicants for DC 20-042 849 East 5th Avenue. Please come forward. If you're trying to speak and you might be muted, I can't hear anyone. Is that you, Miss Stickle? Is that Miss Stickle trying to speak? Because I can't hear anyone. Is she muted, Jamie?
No, is it Ms. Schultz? Ashley Schultz?
Yes, hold on.
There you go. Oh, Miss Schultz, I'm sorry.
I apologize.
I need to swear you in. Swear to tell the whole truth and nothing but the truth, so help you God.
I do.
Would you repeat your name for the record and your affiliation to this case?
I'm the applicant with Permit Solutions.
Okay, thank you. Who's
Mhm.
presenting this?
The first one is mine, Chair Thompson. Are you ready?
Go ahead.
Okay, 849 East 5th Avenue is located at the southwest corner of East 5th Avenue and Lexington Avenue. The site is within the Milo Grogan Area Commission and Zone C5 Commercial. The site, as you can see, well, eventually see when Phil gets there. The site is developed with an existing fuel station. The applicant proposes to remove an existing manual changeable copy fuel pricing pole sign and instead replace it with an automatic changeable copy sign on the fuel canopy, and request variance of single variance to allow an automatic changeable copy sign within the urban commercial overlay. As you know, 3372.606, in addition to signs prohibited in Chapter 3375, automatic changeable copy signs are also prohibited. The Planning Division generally does not support automatic changeable copy signs within the commercial overlay, particularly with respect to fuel prices due to the potential precedent for additional changeable copy signs, not limited to fuel prices. However, planning would consider an automatic changeable copy fuel price sign if the sign were a monument style. That was the initial proposal, was to convert the existing pole sign, which you can see in the screen, to monument. However, there were some issues with the setbacks, so the applicant has since changed to the fuel pricing canopy sign. Columbus citywide planning policies encourage the applicant to reduce the height of, that was still for the sign, don't speak to the fuel canopy signs. However, the Milo Grogan Area Commission recommends approval of this request. Staff can recommend approval as the applicant has agreed to remove the existing pole sign. We're also asking for the following conditions. Automatic changeable copy sign will be limited to fuel pricing only. The commission will stamp the sign elevations and the existing pole sign will be removed. And with that, we'll turn it over to the applicant.
Thank you, ma'am. Go ahead and present your case.
Just to reiterate what Jamie said, we do agree to keep the automatic changeable copy to the price fueling. We will be removing the existing sign, and we will be working with commission to have them stamp the sign elevations as well.
Thank you.
If anyone has any questions, I'm happy to answer.
Any questions? Not hearing any. This application appears to be, finding fact, appears to be appropriate for this location. Do I don't know what that was. I have a motion to approve the finding of fact.
Yes, I'll move to approve the.
Do I have seconds?
I'll second.
All in favor of that, you just sign of aye.
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 Opposed?
Aye.
The ayes have it. And we vote on this now, Mr. Freeze. With the condition, as conditioned.
Right, Mr. Mashinsky,
Yes, Rich Mashinsky, yes.
Mr. Williams,
Yes.
Mr. Cooperman,
Yes.
Mr. Hoy,
Yes.
Mr. Bender,
Yes.
Chair Thompson.
Yes, and it's approved, ma'am. Thank you.
Chairman Thompson, I have to
Yes, sir.
recuse myself for number 2.
All right, thank you. Number 2 is 2283 Sunbury Road. Would the applicant please come forward?
I'm the
Yes, sir.
applicant.
Sir, you swear to tell the
Mr.
truth,
Rose.
the truth, so help you God.
I do.
Would you repeat your name for the record and your affiliation to this case?
My name is Chris Rose, and I am the filing applicant for the variant on behalf of the Mount Vernon Baptist Church.
Okay, thank you. Who's presenting this one? Jamie?
Yep, this is mine. 2283 Sunbury Road is located on the west side of Sunbury Lane, approximately 475 feet north of Hillstone Street. The site is within the northeast. This isn't within northeast, is it? This is within the Near East.
It is northeast, Jamie.
Oh, it is northeast. Okay. The site is developed with a church. Surrounding uses include a single unit residential dwelling development on large lots. The applicant proposes to remove an existing monument sign and replace it with a similarly sized monument sign at the same location, but proposes to add an electronic message center. As the site is zoned R rural, a variance to allow the ground sign to display automatic changeable copy is requested. The northeast area plan supports on-site monument ground signs that do not exceed 10 feet in height. And furthermore, a primary concern regarding automatic changeable copy is the potential precedent for additional changeable copy signs, not limited to institutional uses. The Near East Area Commission has recommended approval. City staff can recommend approval. As stated, the Northeast Area Plan supports on-site monument ground signs that do not exceed 10 feet in height. And although the Planning Division has a primary concern regarding automatic changeable copy, setting a precedent for additional changeable copy signs, staff has historically recommended approval for institutional uses such as churches and schools. Therefore, we are recommending approval and we have no conditions.
Thank you. Would you present your case, Mr. Rose? I may need to recuse myself. I didn't realize what this was. You may present your case.
Thank you. Yes, the church is looking to update their sign. Their current sign is no longer standing as it was damaged in an accident, and we have proposed to have a sign that is 50% the static church name followed by 50% of an electronical message center that does have changeable copy. We will follow all the code. There was some concern in the Northeast Area Commission meeting about the lighting of that, and this will be monitored by a light device. We believe that the church is an institutional use and needs to be able to have that message broadcast to the community and different events and things going on. We do have the support of the Northeast Area Commission. We would also like to note that there are other electronic message centers with changeable copy in that general area. Just think it's a nice sign and would like to ask the commission's approval.
You're aware that it has to be on-site uses and et cetera, no off-site.
Correct. Yes,
Chairman
it would
Thompson?
only be broadcasting on-site uses for the church and no other external advertising.
Chairman Thompson?
I was just
Thompson?
going to say, if I
hold on.
need to recuse myself on this one, should
Yeah.
someone else handle this?
I can take over here. Is there anyone else that would like to speak to this case that wants to get sworn in and speak in support or against this application? Being that the city has recommended approval, I will make a motion to adopt the finding of fact to support the variance requested. Can I have a motion?
Well, can I ask, I'd like to ask a question.
Sure. Sorry, Rich. Go ahead.
That's okay. The drawing shows that it's 12 feet. Is that an issue, Jamie?
No, I think where it shows it at 12 feet, it's at the lower end of the grade. So I think it's 10 feet at the 10 feet at the lower end of the grade. So from street level, it would look like it's 10 feet. So we don't have an issue with that. And it doesn't require variance. It's only a recommendation from the planning commission, or I'm sorry, division.
Okay.
But good catch.
Considering the facts there that even more support the hardship and to adopt the finding of facts. So do I have a motion to adopt the facts to support the variance?
Rich Mashinsky.
Do I have a second?
I'll second.
I have moved second.
All right, all in favor of adopting these set of facts to support a variance, say aye. Aye.
Aye.
All opposed? Okay, it is adopted and somebody can call roll.
Mr. Bender,
Yes.
Mr. Mashinsky,
Yes, Rich Mashinsky, yes.
Mr. Williams,
Yes.
Mr. Cooperman.
Yes, and I'll let Les take back over.
Okay, thank you. I had worked on this site for the church and I didn't realize this was our sign, so thank you. The third one is 1800 North Pearl Street. Would the applicant please come forward?
Yes, Michael Cox.
Yes, sir. Swear to tell the whole truth and nothing but true self God.
I do.
Would you repeat your name for the record and your affiliation to this case?
Yes, Michael Cox with Day Night Sign Company, and I am the agent for the applicant.
Thank you. Mr. Merritt, are you doing this one?
Yes, I am. Thank you. All right, so this is GC 21-004 at 1800 North Pearl Street, located at the northeast corner of North Pearl Street and East 14th Avenue. This is within the University Area Commission and Zone CPD Commercial Plan Development District. The 0.39 acre site is being developed with a multi-story office building in the CPD Commercial Plan Development District. The site is located near Ohio State University and is primarily surrounded by mixed-use development, also in the CPD district. Commercial development along North High Street in the C4 and multi-unit dwellings in the AR4 for student housing. The site is also located within the boundaries of the University Area Impact District and has been reviewed by that body. The applicant proposes 2 projecting signs on the building. The main sign, sign A, is to be located on the southwest corner of the building. The second smaller sign, sign B, is located on the northwest corner. Variances are requested to increase the size of sign A by 156% and to allow sign B to project over an alley instead of a street. The CPD district in this particular case has adopted C4 commercial graphic standards and is subject to the regional commercial subarea. Planning supports the proposal. The University District plan states that projecting signs should be proportional to the building and located above the storefront display windows or transoms and below the second story window sills. The proposal is consistent with the plan guidance, and staff notes that this proposal has been previously approved by the University Impact District Review Board and was issued a certificate of appropriateness, but will need to appear before the board again for a letter of recommendation on this matter. And as stated earlier, University Impact District Review Board has approved this, as well as the University Area Commission. City departments can recommend approval. The proposal is consistent with the University District Plan, as the projecting signs are proportional to the building. I'd be happy to answer any questions.
Thank you. Mr. Cox, would you present your case?
Sure. The signs were designed by the architect, and it's a very small site, and it was a challenge to get the signs to fit into that space and let alone the building. And so the signs that were put in recommended there, plus the viewing distance, trying to get that from High Street and the whole development of that area was a challenge for them. So one of the items with the sign is, even though the size of the sign has been increased, it's the construction of the sign with opaque backgrounds, the reverse channel letters, which, if you could pull that up, I don't think we saw any actual drawings of the signs. So the reverse channel letters, so it's not like they're going to be this big, bright, glowing thing. The actual square footage is for the largest sign is probably about 121 square feet if you take the actual letter shapes. But those are reverse channel letters with internal LED illumination. So the light is reflecting on the back, and it's a black background that's designed to match the facade of the building. There's some black panels, ACM panels on there, and the sign will be painted to match those panels with the proper reflective qualities and that. So and again, we did receive approval, I would say unanimous approval from the UAC and the UIRD. So they did approve, and we did get the recommendation for the variance from them also. The one item on the small sign that projects towards Pearl Street, that sign, the only reason that sign requires a variance is the width of Pearl Street, that it's considered an alley because it's not 35 feet wide. However, the sign does not extend into the right of way. When they designed the space of the building, they provided enough setback for the building, particularly for that sign, so it does not extend into the right of way. But it's the issue of the width of the street that's a problem with that sign. So really, that's I guess that's the case. It's we are looking for the sign. The south elevation is higher than what the required or the overall height, and the size is larger. But again, the lighting is it fits the building. I do have a couple renderings that show the actual signs on the buildings. If I can share that, if that's all right.
I think that's fine. You just need to go to the share content.
Did I
you
do
should
that?
be able to. Up in the top left.
Maybe not.
Do you have two screens?
No.
Oh.
Well, actually, I probably do, because I'm using that one I'm using my screen at the office, so and I'm at home. Technology is wonderful. But anyways, oh, there we go. Is that it?
Yeah.
Can you see that?
Yep.
Okay, so that's the sign.
Yes.
Obviously, it's obstructed because of the construction going on there. That's the sign looking down, looking north on Pearl Street. And then that is the larger sign looking east on 14th Avenue.
Okay, mine's turned off for a minute. Yes.
So is that, again, that's the the Pearl Street sign.
Looks great.
And you can see, even though it's a larger sign than the code allows, it fits with the building the way it's set back. It doesn't back too far. I think it's a nice design. So, any questions? Feel free to ask.
Any questions, anyone? Not hearing any. Find that this is appropriate for this location and this building, and need a motion for approval of the finding of fact.
I'll make the motion for the approval of finding of fact.
Is there a second?
I'll second the motion.
All in favor of the motion, use the sign of aye.
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 Opposed? Hearing none. Motion is approved. Can you call the roll?
Mr. Hoy,
Yes.
Mr. Bender,
Yes.
Mr. Cooperman, Mr. Cooperman.
We lose
He's
him?
gone.
Oh, okay. Mr. Mashinsky,
Yes, Rich Mashinsky.
Mr. Williams,
Yes.
and Chair Thompson.
Yes, and it is approved. Thank you, sir.
All right. Thank you very much.
Moving on to number 4.
I'm recusing
6175.
I'll recuse
Oh.
myself of this one too.
Okay, hope I'm not on. Okay. 6175 Wright Road, would the applicant please come forward?
I am back.
Okay, you've already been sworn, Mr. Rose, so who's
Sir.
presenting this one?
This is mine. Okay, 6175 Wright Road is located at the southeast corner of Wright Road and Gender Road. And the site is within the Greater Southeast Area Commission and recently zoned a CPD Commercial Plan Development District. The 3-acre site is developed with 3 buildings containing a dog shelter with associated offices, training, boarding, and play areas. During the rezoning process, the applicants agreed to signage that would meet community commercial overlay standards or to submit a graphics plan. They opted to instead to submit a graphics plan. The proposed graphics plan will result in a number of wall signs located or labeled as B, directional signs labeled as D, as well as one monument ground sign, which is labeled as C. The ground sign will be directed to Gender Road, which will display automatic changeable copy. Phil, can you go to the next slide? Show the signs I just read off. Phil, are you on delay? Okay, so these are the wall signs, sign A. Next. All right, Phil may be having some computer issues, so we'll just move on. Hopefully he can get back on. The Columbus Citywide Planning Policy recommends monument signs be no taller than 6 feet tall and discourage automatic changeable copy signs. Further, planning recommends changing the main entrance directional sign on Wright Road to a monument sign, as it is the main entrance near the road. C2P2 recommends monument-style signs in suburban areas. As of the writing of this report, no recommendation from the Greater Southeast Area Commission has been received. Perhaps Mr. Rose can address that when it's his turn to speak. City staff recommendation is for conditional approval. Staff can recommend approval of the proposed wall and directional signage as they are of appropriate size and design. However, staff recommends disapproval to the monument sign, which is pictured in the slideshow now. Again, Columbus City Planning Policy recommends monument signs be no taller than 6 feet tall. As proposed, at 9 feet 4 inches, it is too large and contains automatic changeable copy, which are also discouraged by the C2P2 design guidelines. We're not asking for any conditions, and with that, we'll turn it over to the applicant.
Okay, Mr. Rose, present your case, please.
Thank you very much. As Jamie stated here, we are proposing a graphics plan for this campus. A little bit of history here, I'm sure the commission may be aware of, but on behalf of my client, I wanted to make sure that we have an understanding of what Gigi's is. They're a dog shelter. It's a nonprofit organization, and their goal is improving the lives of sheltered dogs. There are many dedicated organizations and passionate individuals across the country working to help homeless dogs, yet they often face challenges that limit their ability to serve dogs in their communities. Gigi's shelter fills a desperate need for these dogs through a collaborative resource network. Gigi's connects existing shelters and adoption centers with expertise and support to improve the health and well-being of dogs and to increase efficiencies within the system. Gigi's business model has been successful. Dogs that graduate from Gigi's are healthier and often find a home within weeks instead of sometimes waiting months to be adopted. They are helping dogs find permanent homes sooner, shortening the time they spend in a shelter. Gigi's is evolving further to improve upon their goal to improve dogs' lives by offering service directly to the public. This new development is what's driving the need for a sign with the abilities to communicate this message to the surrounding community and the public. Gender Road is a highly trafficked area, and having the ability to broadcast messages to the general public about the services offered, upcoming events, and dogs that are available for adoption is crucial. The goal to help these animals relies heavily on being able to reach as many eyes as possible. It can be noted that close to the property, within the 125-foot allocated area, World Harvest Church has a changeable copy message center approximately 5 feet high and 18 feet wide on the west side of Gender Road. Furthermore, Gigi's operations are for the health and safety of the animals. They're a veterinary hospital and now an adoption center. These are very institutional uses. As a 501(c), this organization is not operating for profit. The electronic message center is a crucial component of the graphics plan to allow the general public, the community, to understand and obtain knowledge for the upcoming events and pertinent information. Examples would include adoption schedules, seminars, vet health events, general facility information. It's very important for them to be able to display and communicate these different messages to the public on an updatable and real-time basis through the electronic message center display. They are requesting a setback a little bit inside the normal 12.6 from the right-of-way line. This is on the Gender Road side. We are also requesting the overall height of the 112 inches, and that's based on the design nature and the architectural masonry base to house the message center, which would not be that large, 53 by 99. The tasteful landscaping and visibility for the sign is requesting us to allow that sign to be 9'4" in height. The wall signs, as you saw, were comprised of the halo illuminated channel letters, logo, and non-illuminated lettering. This sign is serving as facility recognition, represents the organization name and logo, and a brief tagline. There's building IDs as well, non-illuminated, painted plate, aluminum numerals, servicing the purpose for general building identification, and routing the visitors to correct areas in the building campus based on their specific needs. There is a main entrance directional non-illuminated post and panel directional sign. This is for the wayfinding information to provide the visitors the correct area of campus. And then there's some parking directional signs as well. Commission, in summary, we are submitting the communal graphics plan application as a comprehensive representation of the signage for Gigi's Dog Shelter. The plan is presented to objectively inform the public of the services and capabilities of Gigi's offers, as well as to assist in the navigation of 3 building complex.
Mr. Rose, seems to be the only conflicting point here is the monument sign. Is there no way to bring it down some?
It was based on the client's objective to have it at that 3-foot height above variance, just based on the surrounding masonry to kind of encompass the sign appropriately. There's also a fence for the dogs, and the fence is 6 foot high, and so it is causing a visual somewhat obstruction in terms of the monument sign being below that. They are moving the fence that's currently there to form a U behind the monument sign in order to help have more visibility on Gender Road. And also, Jamie, in terms of the Southeast Area Commission, we do have full support from them. I'm not sure why you didn't receive that letter. I did attend 2 meetings with them and spoke to members of the community as well in regards to the sign. We actually were able to help a lady. She had complained that there was a light shining in her window from the building, and Gigi's did the right thing, and they alleviated that concern of that light shining there. But
I think you ought to try to bring it down a couple of feet, Mr. Rose.
Phil, can you show that?
Is that possible?
Is that showing up?
Yes.
Now it is.
I'd be in favor of it if you could bring it down a couple of feet. It just does seem to be a little bit larger than it has to be. Any comment?
Yeah, I have a question. So where that monument sign sits, is it below Gender Road grade-wise?
That's a good question, isn't it?
There is a slight difference in grade from where the facility is located and where the monument sign is, and the grade on Gender Road. I can't speak exactly to the fact that if it is below, but there is a water runoff for most of the road that it slopes down and then it goes back up to the property. So based on being on the site, I would say it is probably approximately the same grade as Gender Road.
Can you answer my question about whether or not it's possible to consider bringing it down?
I would certainly entertain that possibility. I would like to potentially see, what if we took out a course of brick per se to bring it down? We just didn't really want to lose that tagline, and then some of that landscaping would go down. But say we got down closer to around 8 feet.
What do you think, Commission?
This is Rich. I'd feel okay if it were 8 feet.
Yeah, I think
It's a foot and a
ultimately
half
it's about
from the third.
visibility.
Yeah.
And being able to see if there's a fence obstructing it. I think having landscape around the sign is always a good thing.
He said he was going to pull the fence back behind it in the U, didn't he?
We are, as you can't have it go all the way. However, driving both north and south, you're still somewhat looking through the fence with your lines of sight until you're up on the sign.
I would agree with 8 feet then, Mr. Rose.
Then we would be willing to concede and bring the monument sign down to 8 feet if we would please the commission. That we'd be happy to do that.
This is a graphics plan, so can we vote on this one as conditioned?
Mr. Bender,
Yes.
Mr. Mashinsky,
Yes, Rich Mashinsky, yes.
Mr. Williams,
Yes.
Chair Thompson.
Yes. It's approved. Thank you, sir. Thank
you.
Our next case is 6115 Park Center. Is that Circle? The applicant, please come forward.
Good evening, Mr. Chairman, members of the commission. Tracy Deal for the applicant.
Yes, ma'am. I need to swear you in. Swear to tell the whole truth and nothing but the truth, so help you God.
I do.
And you are, what did you say your
My name is Tracy Deal, and I am here for Chick-fil-A.
Okay, thank you. Who's presenting this one? Mr. Benich?
Phil Bennett presenting. Thank you, Mr. Chair. 6115 Park Center Circle is located between Park Center Circle and Tuttle Crossing Boulevard, approximately 140 feet west of Blazer Parkway, served by the Hayden Run Civic Association. It's zoned limited commercial. The 1.9 acre site is developed with a former sit-down restaurant and associated parking. There are mature trees and landscaping along both the Tuttle Crossing Boulevard and Park Center Circle frontages, providing some screening. There's also an existing multi-tenant ground sign along Tuttle Crossing Boulevard. Surrounding uses include restaurants to the west, north, and east, retail to the north and east, and a regional shopping center and gas station to the south. The applicant proposes to install signage for a new fast food restaurant, which will replace the current structure. The signage would include a dedicated ground sign along Park Center Circle to the north, a tenant panel on the existing Tuttle Crossing Boulevard ground sign. This is the existing sign. One wall sign on each of the 4 building elevations. The variances are to allow the north wall sign to be 58.75 square feet and located on an elevation that does not have a public entrance. To increase the number of side or rear wall signs from 1 to 2, and to increase the allowable graphic area for the north and east wall signs from 16 square feet to 58.75. So the 2 circled elevations here on the screen require the variances, the others do not. Columbus citywide planning policies note that new signage should be designed to be a logical and complementary component of the overall design of the storefront. The planning division has determined that the proposal is consistent with this guideline, and Hayden Run Civic Association recommended approval of the request. Staff can recommend approval as the proposal is consistent with C2P2 commercial design guidelines, which recommend that new signage be designed to be a logical and complementary component of the overall design of the storefront, with the condition that the applicant commit to the stamp sign exhibits for wall signs D and E here shown on the eastern and northern elevations. Mr. Chair.
Thank you. Ms. Steele, did you have anything to add? You're on mute.
Mr. Chairman, I concur with staff's presentation. We worked extensively with Hayden Run Civic Association, and we also made some alterations to our plan at the recommendation of the planning department. And we are happy to concur with that recommendation, and I'm happy to answer any questions that the commission might have.
Thank you. Are there any questions for her? Not hearing any. Then I need a motion for the fact that I believe this is appropriate use of the signage for the site. The finding of fact.
I make the motion to find.
Is there a second?
Yeah, I'll second.
All in favor of the motion to, or the finding of fact on this, use a sign of aye.
Aye.
Aye. Opposed? Hearing none. Call the roll. Mr. Senator, Mr. Freeze, please.
Mr. Hoy,
Yes.
Mr. Williams,
Yes.
Mr. Mashinsky,
Rich Mashinsky, yes.
Mr. Bender,
Yes.
Chair Thompson.
Yes, and it is approved, ma'am. Thank you.
Thank you.
Okay. Next case is 3120 East Main Street. Would the applicant please come forward? Is there an applicant present? Mr. Freeze, are you aware who we're looking for, or?
It appears Ms. Wilson is not here. I haven't received any communication from the applicant about not being available.
Okay. In case there might have been a miscommunication, is anyone willing to table this?
Yes, I move that we table this particular application.
Is there a second?
I second the motion.
All in favor of tabling this, use a sign of aye.
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 Opposed? The ayes have it. We'll table this one until next month. Is there any other business, Mr. Freeze?
No, Mr. Thompson, there's none. You can adjourn if you'd like to.
And I apologize for it taking so long because of the appeal, but thanks for hanging in there, guys. And
I think
if
you
no
guys
other
did a great
business,
job.
we are adjourned.
Thank
All
you.
right.
Thank you.
Thank you.
Bye-bye.
Thank you.